with regard to the right, which has been occurred upon the advocate by filing the wakalatnama.
No, what I'm on is, Miss Millard, I gave a wrong impression to the court. I think, Millard, the impression that has gone to your court is that a lawyer's representation means nothing to court. That is probably what has gone. But I'm not saying that.
No, not
I'm
nothing, not
saying that
nothing.
I'm saying that I'm saying
Uh,
that the parties, your lordship, is on the question of the conduct of my advocate, not of my client. My conduct of my advocate was that she had consented to something, and therefore she should be held responsible. Now it appears, Milord, from records that she had consented to something which is incorrect. So, Milord, at the highest, that will not bind the client because that is an incorrect submission on fact. So, if it is an incorrect submission on fact, the client will go scot free. My junior can be held responsible for making that statement. But we did take away, Milord, the valuable right of the client for the wrong committed by the advocate. That is the point.
okay, let me consider that.
Why not?
Yes.
My senior is not present today, my lord, for
Huh?
personal difficulty.
No,
We're
I
not,
will reply.
my lord,
That's
there are
only the
two
judge.
judgment, my lord.
Huh.
Tomorrow, first item, my lord, it will.
Milord, I had given my learned friend the two judgments on the
This
previous
was
day.
on the last occasion,
Malad,
that 4th
it
April.
has been given, my
You
lord,
have
my,
taken the time, you will give the
my lord, my
both the
senior
things.
is not present
Who is
today.
your senior?
Surya Bosa Chattopadhyay, he was representing, my lord. My lord, only 10 minutes it will take, my lord, first item, it will lordship can fix.
Sense appearing for the plaintiff, sense appearing for the defendant.
10 minutes, my lord.
It's up to the court.
Counsel for the defendant, counsel for the plaintiff submitted. The arguing counsel is having some difficulties to appear before this court today and pays for adjournment. In view of the submission made by the counsel for the defendant, counsel for the plaintiff, case is adjourned. Let the matter appear on 29th.
Oblige.
Good.
Milord, would it be a lordship's pleasure that if you give a one-page note?
You also come with that notes
All,
on that day.
good.
Yes, next.
Oblige.
I'm for the dependent, lord.
Yes.
The-
Madhavaria letters.
Yes. Lordship is considering the judgment upon admission application. They have completed their submissions. But I'm replying to that, my lord. Now, my lord, 4 judgments have been cited. I'll just summarize their submission, then I'll give response. First, my lord, is on the point that the Duggal judgment and my lord, one of our High Court judgment on judgment upon admission. That's on law. I'll deal with them. There is another judgment which has been cited on the ground that a party cannot take benefit of a mistake. But ILR 41 ILR, and that was cited on the context that I had argued in the Order 7 Rule 11 that the name of the plaintiff and the name of the person who was in the agreement are different and two different entities. So that's that. If because of that,
So
the plaintiff.
then what would affect that you accepted the check?
Yes, ma'am, that I'll answer. Now, check, I'll have good answer. I'll give the answer from facts itself. Although that's not their main submission, but still I'll give answer to that. The mistake, the point that I've argued that parties in the agreement and parties to the suit. The plaintiff is different, and plaintiff therefore does not have a cause of action against the defendant that other party may have, and plaintiff cannot sue in absence of a cause of action. There is no privity of contract between plaintiff and the defendant. To argue to counter that, that I argued in the Order 711 to counter that here judgment have been cited on the point that the party cannot take benefit of a mistake. I'll deal with that. And the third one was that when this application had appeared for the first time, the defendants were not represented. At that stage, the court, not this court, the other bench, had observed that there is an admission in the affidavit. Now, if that admission can be held to be that recording of the other bench can be held as a conclusive observation and therefore can act as interlocutory res judicata insofar as the contention of the play. That is the fourth argument in law. I'll deal all of them one by one. First, I'll show your lordship the pleadings of the judgment upon admission. I don't think lordship had they had taken lordship through the pleadings. From I would request kindly ignore the first 25 paragraphs till page 14. Those are repetition of the plaint.
Which one?
The in application that they are moving, GA number 3, judgment
Yes.
upon admission.
Yes.
So first 14 pages are facts under which the plaintiff had moved the suit. I have already filed my written statement, so that I am not dealing with right now. I have my disclosed my defense in written statement. Thereafter, they proceed that then they filed an application, paragraph 26, page 14.
Page 14.
Page 14, paragraph 26.
Yes.
They proceed that the plaintiff thereafter filed an application for injunction. Next page is the has the order prayers of that application of that injunction application. Now, the lordship had been pleased to pass the first order, page 235 of this voluminous document. Lord, is the order passed by my lord dated 29 September 2022. The order of injunction.
235.
Page 235, annexure L.
Yes.
Up till this, there is no argument, there is no pleading regarding admission. Up till this, that is at page 17, paragraph 27. They are pleading the order passed by my lord, 29 September. Now, ad interim order of injunction has been passed regarding annexure prayer E and H. Prayer H was restraining defendant from dealing with mortgage assets that they are enjoying. Paragraph E is immovable properties of the defendant cannot be sold unless money so realized. The other injunction, lordship has passed this order. So now thereafter, according to their pleading, paragraph 28 of the application, page 17, the defendant filed an application for vacating of this order. Now that was pending. Then both applications were taken up together for hearing, and this honorable court, by an order directed the parties to exchange affidavits in both the applications. Paragraph 30, the plaintiff states in this said injunction application, the defendant number 1 filed an affidavit affirmed on 3rd April 2023, and the same was served upon the learned advocate for the plaintiff on 4th April 2023 by a forwarding letter of the same date. And in the said affidavit, the defendant number 1 has made several unequivocal admissions with respect to the facts of the case. The defendant number 1, in paragraph 5 of the said affidavit in opposition affirmed on such and such, has specifically pleaded and admitted in writing the following facts, and then these facts are quoted. So this is the admission that they are referring to. An affidavit which my client had filed had affirmed. Now, my lord, for the time being, I'm skipping this portion. I'll answer to that. Paragraph 31, my lord. The statements made in those paragraphs of that affidavit in opposition are admissions of the defendant number 1 with respect to the creation of the mortgage, subsequent execution of mortgage deed, and the relation of the defendants with respect to the said mortgage. That is the admission, according to the pleading of the plaintiff.
Yes.
There is, so it is not also not the case of the plaintiff that there is an admission of any liability. Admission is of mortgage, admission is of subsequent execution of mortgage, and admission is of relation of the defendant with respect to the mortgage. None of these three facts I am denying in my written statement. I am not saying that there is any mortgage agreement. I am also not saying that there is a subsequent mortgage agreement registered. I am also not saying that the defendants are party to the mortgage agreements.
Yes.
These are all part of the pleadings. I am saying that it is not the plaintiff who was other party in the mortgage agreement. It was someone else, some other entity who had never come before the court.
So if you are admitting the execution, so who are the other
party, the named party in the agreement? The name of the party in the agreement and the name of the plaintiff are different. They're two different companies.
So in this suit, if you come to paragraph 31,
yes, my lord,
they made 5A to E of the affidavit in opposition and admission of the defendant number 1 with respect of the creation of mortgage,
Yes,
subsequent execution of mortgage deed, and relation of the other defendants with respect of the said mortgage.
absolutely, my lord.
Correct.
There is no admission, according to them, on the defendant's liability to repay under the mortgage.
Leave aside liability.
Yes, my lord.
Just now you stated that you had admitted. Now
Yes.
you are telling that the party who are in the agreement, you are not the party.
No, I am that. No, I am saying that the agreement has two parties. For the agreement has two parties. One party, according to them, me, is a defaulter. The other party is not the plaintiff. It's someone else who has not come before the court. That is a different company who has not come before the court. Plaintiff has filed this suit on the basis of a mortgage agreement of two independent companies. Plaintiff sues one of them and steps into the shoe of the other without any authority, sanction, or consent. Plaintiff has to show that the other party in that agreement has authorized the plaintiff to sue. There is no pleading. That's not the case. Plaintiff is saying it's a
There is a
mistake.
deed.
Yes, Miller. Lordship had considered these deeds, Miller, in the application for dismissal of the plaint. Miller, first I'll show Miller, kindly come to page 43.
Yes, 43.
Yes, who is the plaintiff? Miller, kindly see the
Sheila Jain.
Sushila Jain. That's the defendant. 42.
Susila Jain is the defendant number 1. Correct.
Yes, that's the mortgagor.
D1.
The mortgage. Kindly see the page 44
44.
and confirming party Madhava. Kindly 44 towards bottom, Miller. Mortgagee is referred as Madhava Real Estate Company Private Limited.
Now Sunil Jain.
The
is the
defendant.
guarantor.
The defendant, guarantor, yes. Those are defendants. Miller.
D2.
These
Then
are two defendants. Then the Comsource Data System Information Technology Private Limited.
correct.
He is also another defendant. Defendant number 3.
Yeah, defendant number 3.
Now next name. Madhva Real Estate Company Private Limited. That's the mortgagee.
Yes.
Kindly see the name of the plaintiff, Miller.
Madhava Realtors.
And Madhava here, Madhava Real Pro Private Limited. Two different companies.
Correct. Now this agreement,
Hmm.
this deed, which paragraph the plaintiff has dealt with?
Yes, paragraph in the plaint.
Hmm.
In the I'm
No,
showing from the
because-
application.
because-
Yes.
Because this paragraph 31.
Yes, paragraph 31. Yes.
Paragraph 31, paragraph A to E of the affidavit.
That is my affidavit.
Where is that?
Well, that is at pages towards the end of that application, that page 240 257. 47.
From page 247 in
It starts at
GH3.
page 247. That portion is at 252.
252. Supplementary agreement entered between the same self E to H, na?
Yes.
It was agreed answering response. So
A to E, well, announcement refers to A to E. So A is at page 251.
251.
And
Answering
from that
response file
onwards,
vacating application, second instant application, the answering respondent for the prevailing loan, mortgage deed on 17th February,
yes,
and this deed is also 17th February.
my lord.
Correct. So you have not stated that the deed which they have planned, they have relied upon. It is not the deed.
I will show that those are the pleadings of this very affidavit. In subsequent paragraphs, the deponent with some other set of advocates had pleaded those in the subsequent paragraphs of the same affidavit. My learned friend, what they are showing, there are other subsequent events I will show, but here, this affidavit, they are showing a part of it and not showing the other part of it. Kindly see page 255. In fact, before that, kindly paragraph K, page 255. This particular point of parties being different from the agreement and the plaint are specifically pleaded. Page 255, paragraph K. In that very affidavit, which my learned friend says says or claims to have come in his aid.
Which paragraph?
Page 255, paragraph K.
Paragraph K.
K.
Yes.
The particular point of two different parties, Real Pro and Madhua, the Real Pro and Real Estate.
Yes.
So that it is not that the situation was not pleaded, it was still pleaded. But what happened? This affidavit was mistakenly filed, and this part is recorded. How? I'll show the orders of this court. That Lordship would kindly come to, since Lordship is going through this part of papers, page 267. Page 267. Now, this affidavit in opposition was filed, was affirmed, copy was served, and on the same day, not on the same day, next day, they were intimated that please don't refer to that. It's a mistakenly affirmed affidavit. We are withdrawing this. We are giving you fresh affidavit of opposition. They did not stop. They prepared their affidavit in reply on the basis of this very particular affidavit in opposition after receiving my communication of withdrawing the same. Be that as it may, we both go to court. I come with the new affidavit in opposition to GA1. They come with the affidavit in reply to the earlier affirmed affidavit in opposition to GA1. Considering that, at page 267, the Honorable Justice Mukherjee had recorded these part. There is utter confusion in the matter created by the defendant number 1 while filing affidavit in opposition to this application. Initially, an affidavit affirmed on 3rd April was served upon the plaintiff. On the basis of thereof, the plaintiff obtained a direction to file reply thereto. The affidavit in reply was affirmed on 12th April. On the same very day, the plaintiff received an electronic mail from the defendant number 1 saying that the affidavit in opposition affirmed on 3rd April and served upon the plaintiff was by mistake, it should be disregarded. The defendant number 1 has now affirmed another affidavit on 19th of April 2023. The said affidavit filed in court today is taken on record. Thereafter, next page, without prejudice to the rights and contention of the plaintiff petitioner, if any, in respect of any admission said to have made in the first affidavit affirmed and such, the plaintiff petitioner shall be at liberty to use an affidavit in reply to the plaintiff in opposition affirmed on 19th April. Let such affidavit in reply be filed on 10th May. The interim order is extended. So,
without prejudice to the rights and contention
of the plaintiff, if any, in respect of any admission said to have been made in the first affidavit affirmed.
Correct.
That is the right and contention that they are exercising today. The judgment upon admission. But Millard, this point of mistakenly filed affirmed affidavit and Millard thereafter a subsequent correct affidavit are all before the court at that point of time. We are not making any new story today. This is there, status is there from 24th April 2023. This order dated 24th April. So, this affidavit was a result of a mistake of a junior advocate who is then thereafter there was change of advocate. After all these, of course, Millard parties, the litigants are not satisfied with the conduct of the early advocate, so they took a change. They came to the present advocate on record, and then we are taken over and continuing. Now, Millard, this is one part of admission. They say that in that affidavit, you have admitted the mortgage deed, and you have also admitted that there was subsequent mortgage deed, and you have also admitted
there is a new affidavit.
Yes, that they have suppressed in the application. We have disclosed in our opposition to GA3. Page 23. Page 23. Is the affirmation.
Yeah, affidavit in opposition guy.
23 Page 24 is the communication of that email. I'll show they have suppressed all these things. So I have disclosed these documents. Page 24 kindly comes to page 24. It is the email of 12th April.
Page 24
of my opposition. But page 20, email below. Email. Page 20, page 8. Kindly come to page 18. Page 18. My mistake. Page 18.
Yes.
That email Lordship had referred in the order has shown Millard.
Yes.
The kindly see the time of this email, Millard. 9:22 a.m. at the top right hand corner.
Yes.
But at this hour, it's early in the morning, they could not have affirmed that affidavit in reply before this hour. Their case is that they had affirmed that on that 12th April itself. Their case is that they have affirmed the affidavit in reply on 12th April. But that affirmation could not have taken place prior to 9:22 a.m.
Whether this affidavit was affirmed?
This was affirmed. This was affirmed and served. There is no denial about this. This was affirmed and served, mistakenly done, but affirmed and served. They say this was served upon them on 3rd of April. They say that they on 12th of April filed a reply, affidavit in reply, and on that date there was no other affidavit on record or served upon them. But I am showing on that very day, early in the morning, before their affirmation of their reply, I have already intimated that, as you are aware, we have served you a copy of the affidavit in opposition in GA1 on behalf of the client above named in the aforementioned manner. Please note that we have inadvertently served you the unsettled draft of the affidavit in opposition and we wish to withdraw the same. We request you not to proceed with the said affidavit in opposition. We further assure you that we will serve the final copy of the affidavit in opposition upon you at the earliest. And thereafter, and then they affirm they did not stop. Of course, they did not stop. They affirmed their affidavit in reply on the basis of that draft affidavit in opposition, and that was on 12th. Thereafter, my lord, on
You
19th
filed the
of
affidavit in reply.
my lord,
When you filed the affidavit in reply?
I did not, my lord.
Affidavit.
Yes, the
Next
next
affidavit.
19th, next page 20. Page 20. Page 20, kindly 19th of April. In reference to our email dated 12th April, please find attached here with the copy of the affidavit in opposition on G number 1 filed on behalf of our client above named in caption matter.
So the affidavit earlier which you affirmed,
Yes.
that was filed in the court.
No, that was never filed in the court. That is why when your lordship asked me, lordship called for a record, it was absent. Lordship asked me to clarify why this is not being produced. And our specific stand is because it was only affirmed and never filed in court. It was kept with the advocate on record, early advocate on record. And thereafter we have taken change. That affidavit never reached the present advocates and it is also not in the office of the early advocates. So that is the now stage, my lord. Then, my lord, kindly come to page 23. That is the correct affidavit in opposition to GA number 1. Which they should not have suppressed this while filing an application for judgment upon admission because final decree, they are seeking final decree. But suppressing documents at that stage will not.
So the affidavit which you affirmed, though you are not filed
Yes.
and served,
Yes.
and they are relying upon,
They are relying
it
upon.
cannot be taken as a otherwise.
Yeah, they are trying to take it as otherwise. There is no two ways about it. They are trying to take it as otherwise. I have explained that even if that affidavit is taken to be even if it is taken that there are admissions in that affidavit, the pleadings of it and the pleadings of the plaintiff in the judgment upon admission are that the admission in respect of mortgage deed. That's all. There is no.
What would be effect of the contrary affidavits?
But the settled position of law is that I am carrying those judgments that the affidavit, if can be the admission, if can be explained, cannot attract any judgment.
One affidavit is you filed.
Yes.
Or a filed affidavit containing some admission.
Yes.
Subsequently, you have filed another affidavit. Though you have not filed the same in the court, so question of not pressing does not arise, but
Yes.
it is served.
Yes, it is served.
And admitted it was affirmed.
Yes, admittedly
And
affirmed.
admitted it was served. And subsequently, what stand you have taken with regard to that paragraphs in the subsequent affidavits?
I have dealt with those paragraphs were said as preliminary paragraphs. So kindly see paragraph 3, page 25 of my affidavit in opposition.
25.
Yes. Paragraph 3, the same manner as lordship had found in the earlier affidavit, other affidavit, I have given the basic facts. In the basic facts, I have nowhere said anything about the mortgage deed and everything. A, B, C, D, E. In the same manner, it was pleaded there with the, I would say, acknowledgement of the mortgage deed. In this affidavit, there is no such acknowledgement. Now, that I am taking my case as the best case, saying that even if the mortgage deeds are admitted, that does not make me liable to repay under the mortgage because the relief under mortgage is squarely different. They are not asking for redemption of mortgage; they are asking for money relief. They are in one hand saying that they have received money. So mortgage, they are not asking to get the possession, or they are not asking to sell the properties so that the money can. Those are not his. Now his case is not of redemption. or foreclosure. His case is refund of money. It's a simplicity of money case. Now in that, the liabilities of different. I have nowhere. It is not also their case that I have admitted my liability to repay. I have not, and particularly in view of the fact that it's not the same party who has come before the court. Under the mortgage, someone else was entitled.
If you say that it is you're not liable to pay the amount,
Yes.
liability, whatever it may be. So what about the check?
Now I come to the check.
That is the only. These are the three things they are relied upon.
Check is not their. I have read their pleadings. They are not going by the. I couldn't find that those paragraphs where they are laying upon the
Now,
checks.
what Mr.
Verbally, they may have argued this, but this is not properly pleaded, I would say. Be that as it may, I have answers of check. Checks were given in 2017, undoubtedly. To whom? The party under the agreement. Those checks were all returned on the ground that the addressee name is different because those are presented by the plaintiff. Then, on the series of checks, 2 checks were withheld by them. So, 1 check was withheld by them. What they had done in 2022 before filing of the suit, that they had deposited that very check, which was earlier returned, and that will come up from the numbers that used a 2017 check in 2022 to create further cause of action and got it returned on the same acknowledgement that addressee name is different. It is not that funds are insufficient or accounts closed, nothing like that. Addressee is different because addressee is the addressee in the agreement and not the plaintiff. So, in effect, what they are basically trying to sue me on behalf of someone else without taking consent of that someone else or any pleading. Their simplicity argument is that someone else name in the agreement is a mistake.
Okay.
So these are not on facts. Because Lordship asked me on checks, I'll also show page 130. Yes. Kindly see the checks, Milord. Return memo I'll show. Page 130 onwards are the checks. এখানেই তো ডেট লেখা আছে। Kindly see the dates of these checks, Milord. The first one, page 130.
Yes.
Now, Milord, in 130 to 133, Lordship would find 4 checks.
Yes.
All dated 2021.
Yes.
Now, kindly match, Milord. This is the conduct of the plaintiff is this, that they have, Milord, reprinted, Milord, 2 pages of the same checks. Kindly sees the check numbers of first check, Milord. Kindly, the check number would match. Kindly see the check numbers, Milord. First page number 130 at the bottom, 582. Check number 582. The next page 131, 582 again. Same conduct, 132 and 133. Same page, same check numbers, 581 and 581. Twice. So Lordship is given an impression that by these checks of 50 lakhs each, 2 crores are being repaid or promised to repay. That was the quantum under the agreement. And actually, only 2 checks were used. And those were printed twice and will not come in the application. There is no clarification in they are saying that by these checks, 2 crores were being, how without, by the same 2 checks, I can repay 2 crore. This is one. Now that these checks, Lordship would find from the numbers of the check, the numbers would align with the number of the earlier checks of 2017 and 18, which are annexed from the next page onwards, 134. Each of the same series. Blank checks were taken. Those, yes, most of them were filled up on 2017-18. 2 were withheld. Those were used subsequently in 2021 only for the purpose of instituting the suit. Otherwise, the suit is barred by limitation. Their case, they tried to save limitation with these 2 checks. And now they are showing it as 4 checks, giving impression of 2 crores. And all these checks, return memo, Lordship would see the return memo. Return memo says account addressee name different. All checks up to 143 Milord, 140, yes, 140.
Yes, they have mentioned page 129. They have given the description of the paper.
Yes.
Checks 129. They have given 1, 2, 3, 4. 8 checks up to 2017 and 18.
18 checks. Now, Milord, my argument in Lordship would remember in order 711, I argued that uh, 2017-18 checks. If I take them, then those were dishonored. 2021, the 2020 limitation expires. Now, to that, their argument was COVID-19 pandemic. They could not institute the suit. But it was decided, and they were arguing. These two applications were arguing together, being heard together. So, my response to that argument, I'll just finish that in one. I'll take 2 minutes on reply to that. Now, this is the conduct of the plaintiff, and also in respect of the other checks, page 134, 135. All these are their repetition of same check numbers. Now, kindly see the names to which these checks were named, to which these checks were issued. Those Mother Real Estate
Company Private
Limited. And to who is suing? Madhava Real Pro Private Limited. So this is the reason why these checks were dishonored. Addressee name was different. They have not annexed the return memo, but my lord, from my affidavit in opposition, in fact, those were there in my order 711 application. I have disclosed the return memos were all on the ground of addressee name different. Yes, my lord. In fact, lordship would find it, page 131, 132 return memos are there. Payee name differs. Page 131, on the first part of the document, payee name differs. The same acknowledgement is there in every return memo. They have not attached the other ones for 2017-18, but it has the same acknowledgement. Payee name differs. So there is no dishonor of check and attracting a liability on that basis, because I have not defaulted in paying him, the plaintiff, and the one I have tried to pay did not present those checks at the right time. I tried to repay the one in the agreement, Real Estate, Madhwa Real Estate. He did not present these checks. These checks were presented by the plaintiff. So even if those were, I do not know.
So as per your case, the earlier checks, that is the 2017-18,
Yes.
are all on the name of the Madhava Real Estate Company Private Limited.
Yes. Madhava, there was no check given to Madhava Real Pro. Madhava Real Pro used two checks of the same series.
That series they have used as a Madhava Real Private.
Yes.
And they have filed the case.
They have filed the suit later on, 2021.
You have given the blank check earlier.
Yes. Now, that had these earlier checks were presented by this particular entity, Madhava Real Estate Company Private Limited, those would have been properly honored. This is my submission. They were never tested. They deposited it, came back as addressee name different.
138 is filed.
No, they cannot, because it's a fraud on code. They cannot do it.
Yes.
Now, they neither for this and not for the subsequent two checks, because here the lordship would see in the 138, 136, 133, those checks are written in hand. The newer ones are printed. Kindly see Madhava Real Estate, the handwriting would not match. They know that these will not match, handwriting will not match, dates will be different. Handwriting will not match. If I contest it 138, they will lose. And the other consequences would follow. So that is why, and there is no real, the addressee name is different. So they can't sue me in 138. They are trying to use those checks in this suit. There cannot be any admission on basis of checks given to third party. I have not given any check to the plaintiff.
Yes.
So that admission is gone. The admission in respect of the pleadings, I have shown. I have twofold argument. One is I am only even if such can taken it to be admission in respect of mortgage deeds, not of liability. The other is that I have already clarified it immediately thereafter in 7 days time, and that particular subsequent affidavit is recorded in order of court. And court, the last admission that they say is that the order of Justice Mukherjee.
Which one? Which order you are relying
But
on?
I am not relying, but they have shown an order. Now, which order? They have shown an order of Justice Mukherjee,
4th March.
4th March order, where, my lord, I just would like to place, because they say that this is a recording or a conclusive recording of admission. according to them, this and it's also submitted very strangely that because I have not challenged that order, I can't argue on those points in the final hearing stage. So it's like under Lordship passes an ex parte order. If I don't challenge it, then on the affidavits I can't argue. That's their submission. Because that would operate as interlocutory res judicata against me. But can that be the law? I am asking this question to myself. If I don't file an appeal from an ex parte order, I will not have a chance to contest it on affidavits. That's their submission. Kindly see that order.
It clearly records that
Yes, yes,
the
clearly,
order
I'll
was
show.
not an ex parte order. Kindly
Absolutely.
see the 2 orders before that, and
No, I'll show
there
that
also
very
it is
order. You are
specifically
relying upon
recorded.
that order has been shown.
In that, his name is recorded in that order.
Order copy without. Kindly see 4th March order, Miller.
Yes, second page, last paragraph.
Yes.
Second
That
page,
is what they are relying upon.
last paragraph.
Yes.
On perusal of the argument, in support of the break, I find that there is an admission
Yes.
as to the receipt of the loan amount,
Yes.
the mortgage deed, and the repayment as per the supplementary act.
Now kindly comes to the next page. Page 3. The defendant number 1 is represented by an advocate who submits that due to change in advocate, he is appearing for the first time and requires the case time at least to get himself ready. The line advocate on record, such and such, who says that he has received instruction from the defendant to appear, has not even filed wakalatnama. In the absence of the wakalatnama, the line advocate do not have any right of audience. So we were not even heard. Although we are present in court, there is no doubt, but we are not even heard. And without hearing us, and rightly so, because we did not have wakalatnama on that day, rightly so, the court has observed that there is admission as to the receipt of the loan amount, the mortgage deed, and the repayment as per the supplementary agreement. This is the observations of the court. Now, their argument is that I am therefore stuck, restrained by interlocutory res judicata, and I can't argue the matter in final hearing when this has come up. But this particular argument has tried to be supported by a judgment. With that, I will distinguish, Milord, that this is completely, it cannot be an argument in law that a party does not challenge an order of an ex parte stage or in ad interim without affidavits, cannot thereafter argue the matter on affidavits at the final hearing stage. There cannot be any law. This interlocutory res judicata is not a proposition for that. Interlocutory res judicata, Miller, is a proposition where Miller, it just for the time, is used, Miller, to show that the res judicata is applicable in different stages of the same proceeding, can also apply in different stages of the same proceeding. Now, judgments that they cite, no, these are 2022. The judgment they cite is that 2022. 2020-22 SEC Online, Supreme Court 1450.
Which one?
2022 SEC Online, SC 1460.
2022.
Yes, 2022 SEC Online, Supreme Court 1460. This is what they are, Milord, citing.
What is the name of the party?
But S. Ramachandra Rao, that may not, or she may not have a SEC Online copy. Yes. But I have the SEC Online copy. That maybe, Milord, there may be difference of paragraphs.
There's a print of 2022 SEC Online 1460.
Yes.
Yes. Next.
Kindly come. I'll distinguish. This has been shown. Argue that interlocutory res judicata at that point. Now, that kindly see the facts of this case. Paragraph 3. First of all, the issue in this case is completely different. The issue is that the issue involved in the matter is concerning the capacity in which the plaintiff appellant's wife, who is a general power of attorney holder of the appellant, is also an enrolled advocate, could appear and act on his behalf in the said civil proceedings. That's the issue. So, but then, be that as it may, I'll kindly come to paragraph 7.
Yes.
Although this was the main issue, but other points of law are discussed, so Supreme Court observations are also binding. So I'll deal with that. Paragraph 7, Miller. Paragraph 7 on 27 September 2011, an application being I number and such was filed.
Paragraph 7.
7. But that may not match. That's the because it's also not matching with our copy. Maybe a true copy print or a different copy. But it starts with on 27 September 2011. It's just 2 paragraphs after that.
Yes.
On 27 September 2011, an application being I number 1308 of 2011 was filed under Order 3 Rule 2, read with Section 151 of the Civil Procedure Code, read with Section 32 of the Advocates Act, read with such and such of the Evidence Act, with the prayer that the GPA holder of the appellant be permitted to appear in person and to plead, argue, and do all necessary acts for conduct of the proceedings. I'll stop here. This was the application filed by a party. Kindly come to paragraph 8. Now, kindly come to the last part of this paragraph, the one we read. The trial court, by its similar orders dated such and such, allowed the application so moved and granted the prayer so made, while rejecting the contention urged on the behalf of the contesting respondent with reference to Order 3 Rule 2. The said order of 19 February is as passed, reads as under. So the order was passed. Then paragraph 8. The aforesaid order dated 19 February 2018 were challenged by the contesting respondent in the High Court. The High Court, by its common order dated such and such, confirmed the order of the trial court, but while clarifying that the wife of the appellant will appear in person as power agent of the appellant, but not in her professional capacity as a lawyer. Now that part is there. Paragraph kindly it comes to paragraph 10. This is the different stage of the same proceeding. Thereafter, another application of similar nature in relation to that suit was considered and allowed by the trial court by its order dated such and such, while rejecting similar objection of the respondent and while observing as under. Then the observations are there. Now kindly straight away kindly comes to next paragraph 15.
Starts from?
It starts with Miller. Thereafter, the High Court took note. So there was difference of opinion of the courts in respect of similar applications by similarly situated persons.
Yes.
And in one case, it already held in favor of one party. Thereafter, the High Court took note of the previous applications moved in these matters and the orders passed thereupon, while stating its construction of such previous orders inter alia the following terms.
Yes.
The said order came to be possession month of such and such as, well, I am not reading this part. This Willard says that there are earlier contrary orders. Now kindly comes to paragraph 20. 21. Now under these circumstances, two different contrary orders are passed in respect of two similar applications. The basic principles of res judicata are generally specified in principal part section 11. I am not reading this whole part. This is principle res judicata. 21 is that. 27. The principles of doctrine of res judicata is attracted not only in separate subsequent proceedings, but also at subsequent stage of the same proceedings, is hardly of any doubt or dispute. So it has to be a subsequent stage of the same proceeding. Here we are at the same stage of hearing of judgment upon admission. We are not in a different stage. It is not that in one application something has been held and the other application held finally, and in other application something else is being argued. It is not the case. It's only applicable at subsequent stage of the same proceeding. Now kindly go to page 32, paragraph 32. In true application of these principles. It starts with in true applications of these principles. Paragraph 30. In true applications of these principles. Then 3 paragraphs thereafter. There, because the court has clarified the issue regarding the facts of that case. Paragraph 32, I am just reading it. In true application of these principles, it would appear that the orders passed in these matters by the High Court on such and such dates, as regards the issue of participation of the wife of the appellant in these proceedings as GPA holder of the appellant, remain binding on the parties and cannot be ignored. In other words, this issue concerning the capacity of the wife of the appellant to participate in these proceedings as his GPA holder cannot be agitated over again in these very proceedings, even if the earlier orders granting such permission to her are suggested to be erroneous. Here, in that case, there were conclusive decisions on giving permission to a party, and thereafter, when such permissions were subsequently denied to some other party, the court has observed that no, it is already binding, and therefore it cannot be ignored.
So
And
fourth March order on what circumstances it was filed?
it was the same application was being heard. The IAG number 3. IAG number 3 was placed. In fact, Millet, I was present in court. Was placed. We did not have Wakalatnama on that day. My advocate on record did not have Wakalatnama on that day. So we also tried to explain. But the court said you don't have an Wakalatnama. How can I hear you? And court did not hear me. And I'm not alleging anything. It's right. If I do not have Wakalatnama, Lordship will also not hear me today. Now, thereafter, I filed the Wakalatnama, and that is why I'm being given this chance of argument. But that very application was being heard, which Lordship is hearing today. Affidavits were complete by that time. So, but our affidavit was not found in the record. So, I thereafter, with your Lordship's leave, I filed the affidavit. But affidavit was actually complete, is recorded in the order. Now that it's final hearing stage, that was also final hearing stage. So, that order is not a conclusive order of anything. Court had heard them and observed. On perusal of the argument in support of application, I find there is an admission as to the receipt of the loan amount, the mortgage deed, and the repayment as per the supplementary agreement. But even then, the court does not
on
say.
perusal of the argument.
Yes, in support of the application. But next page, next paragraph, court records, the same court, that the defendant number 1 is not allowed to argue because he doesn't have Wakalatnama. Just the next page. So if I am not heard and an order is passed, not in my absence, in my presence, can that order be held against me and said that you will not be able to make argument thereafter at any point of time on these issues?
Okay.
So these are the points on interim.
Yes. Next, anything?
Next pillar is that the issue of the different plaintiff and the different party in the mortgage deed, that they are trying to argue that they are trying to argue that we are trying to take benefit of a mistake, and a judgment has been cited. Particularly on this point, 41 ILR, page 540, 548. The name of the case is WC Bins. It's a pre-independence judgment, so 1934 judgment. Undoubtedly. WC Bins. Kindly seize the judgment plot. I'll start from the beginning. I'm distinguishing this. Kindly bear in mind that they are citing this on the ground that a party cannot take a benefit of a mistake. Now that here, I am not arguing of any mistake. The argument of mistake is from them. The plaintiff is arguing that there is a mistake in an agreement. I am not arguing any mistake. I am saying that the agreement is correct. You are the wrong plaintiff. The plaintiff is saying that no, there is a mistake in the agreement. My name should have been there in the agreement, but it is not there. However, this was the understanding of the parties. So, if there is anyone who is taking any benefit of any mistake, it's the plaintiff, not me. Now, kindly read, under these circumstances, kindly read this judgment pillar. In this suit, the plaintiff claims that by a written contract dated such and such, the defendant company agreed to comply him for a period of 4 years from that date on salary of such and such until December 1, salary of rupees 460 per month until December 1932. Then Millard kindly comes to the next page. The plaintiff claims that the defendant company repudiated their contract and sues for damages. It's a contract for personal service. So, kindly comes to thereafter page number 550 of the report. After discussing the evidence, the court came to the following conclusion. I find that the plaintiff agreed to accept a salary of rupees 500 on the 15th April and that the agreement was drawn up for a salary and such owing to a mistake on the part of the defendant and did not express the intention of the parties, and that the plaintiff, fully realizing the mistake, deliberately sought to take advantage of it. Then Millard kindly comes to So this is the finding of the evidence, the mistake. The mistake of the plaintiff and this way. Page 552.
5.5.
552. Last paragraph. It was argued on behalf of the plaintiff that even if there was an error in drawing up the agreement and even if the plaintiff acted fraudulently in seeking to take advantage of that error, the defendant company could obtain no relief in the case, but must, in order to obtain relief, file a suit for rectification of the agreement as drawn up. This was based on the ground that there was no counterclaim for rectification. In that case, the defendant in a suit for rent sought to set up a defense that the lease was fraudulently drawn up and did not correctly express the agreement between the parties. Thereafter, I'm skipping this part, kindly comes to last part of that paragraph. In my opinion, the general rule is stated by Jenkins CJ, but even if the matter is one for the discretion of the court, that discretion should be exercised in this case in favor of the defendant company. Why? In this case, the defense was not that the defendant company claimed that the agreement should be rectified and enforced as rectified. The plaintiff had, on his own evidence, repudiated the agreement set up by the defendant company. No suit would lie for specific performance of the contract of the agreement as set up by the defendant company. The defense was that the agreement set up by the plaintiff was obtained fraudulently, which was always a legal defense. Then, my lord, kindly come to page 555, middle part. I notice that I'm showing the undoubtedly, the paragraph has the lines has to undoubtedly. It's a question of damages. In my opinion, the plaintiff cannot decline to mitigate his damage on the ground that owing to his own conduct, he had made it too difficult to accept his offer made. He cannot increase his damages, his own default, such and such. So, the relief was denied on the basis on the same situation. I'm thankful to my learned friend. He has come up with the judgment which denied the plaintiff from getting any relief because of the argument of mistake, which the plaintiff is making here. And kindly sees if there is any truth in the plea that there should have the plaintiff's name should have been in that agreement, or either way, for the last 5 years they are litigating. Scope of amendment is there. They did not take any step for amending their plaint or bringing that party in the suit. So even if they run this case up to trial, they cannot prove anything because the party, the most vital party, is absent. I have already filed my order 711 particularly on this point. There is absence of any cause of action or any privity of contract. The last two judgments on the ground of judgment upon admission, that proposes that judgments on judgment upon admission, that proposition, the Duggal and other 2014 judgment of our court, lordships have held. Considering Duggal, I am carrying those judgments passed by my lord. 2025 SEC Online Calcutta, the Duggal judgment has para 14 and 19 have now been distinguished. And this is presently the view that 2000 volume 7 SEC 1 2025 SEC Online Calcutta 528. না এক্সট্রা কপি দিয়ে দিলাম এক্সট্রা কপি কোটে 2025 SEC Online Calcutta 528 কি কাজ রিপ্লাই হয়নি 2025 SEC Online Calcutta 528 paragraph 14. I am citing this to distinguish their judgment. I am not citing any new judgment. They had cited an old law. I am citing the new law, which is now is operating in the field. Paragraph 14 and 19. I am reading it, Millard. The plaintiff says that the defendants unable to explain the admission about the balance confirmations, and thus the plaintiff is entitled to get judgment upon admission. In this context, plaintiff has relied upon judgment of Uttam Singh Duggal, 2000 volume 7 SEC 120, wherein lordship has recorded it. Paragraph 15. I am leaving paragraph 15, 16. 15 and 16 are other judgments, and not kindly comes to the next second paragraph of paragraph 16. In the present case, the plaintiff has relied upon the confirmation of accounts. The defendants have denied with regard to the same. Firstly, on the ground, the defendant numbers 2 and 3 have not issued the said balance confirmation. Secondly, no tax deduction at source shown by the plaintiff with respect to the said balance confirmation. Thirdly, the defendants have taken specific defense that the said amount is not of loan and which with regard to the investment in the real estate project, and the plaintiff has suppressed the agreement entered between the parties. Subsequently, the defendants have brought the said document on record by way of supplementary affidavit. when the defendants came to know about the criminal case initiated by the plaintiff against the defendant in which the plaintiffs had disclosed the agreement. Thus, the said judgment are distinguishable from the facts of the present case. Then Miller, paragraph 19. Now, Miller, this judgment was cited by the defendant in that case. The defendants have relied upon judgment in case of 1999 8 SCC, wherein the Honorable Supreme Court held that under Order 12, Rule 6 of the Code of Civil Procedure, the court, at an interlocutory stage of the proceedings, pass a judgment on the basis of admissions made by the defendant. But before the court can act upon the admission, it has to be shown that the admission is unequivocal, clear, and unambiguous.
Yes.
And positive. In the said case, the Honorable Supreme Court relied upon the judgment in the case and such, wherein the Honorable Supreme Court had held that Order 12, Rule 6 to be read along with the proviso to Rule 5 of Order 8. This is to say, notwithstanding the admission made by the defendant in his pleading, the court may still require the plaintiff to prove the fact pleaded by him in the plaint. In the present case, the plaintiffs have relied upon the confirmation of accounts as admitted documents and prayed for judgment upon admission. The defendants have taken a specific defense that the said confirmation of accounts are not signed by defendant number 2 and 3, and there is not a single instance of deposit of tax deducted at source by the defendants. And thus, the same cannot be taken as confirmation of accounts. The defendants have a specific defense that the said amount is invested in the project, but the plaintiff has stated that the said investment is with regard to Vedic privilege, which is no way connected with the present case. So there was ambiguity in the present case, but there cannot be any bigger ambiguity than the present case. Here the plaintiff is a different party from the document which he sues, which on the basis of which he sues. The plaintiff has that I have shown how the checks were printed twice and shown. I have shown how the checks of 2017 series are tried to be reused in 2021 to file the suit. I have also shown how the main defense, the subsequent affidavit of the defendant, was suppressed from the application, which we have disclosed in the opposition. I have shown my present stand. I have said the mistake, and the mistake is of 2023. I have clarified that, recorded in the order. I have also shown the other admission which is sought to be argued is of Honorable Justice Mukherjee's order. I have shown I was not heard. So at interim stage, an observation of the court is there. It cannot be that I am bound by it and court cannot take a counter review. Otherwise, from all orders, there has to be an appeal. That can't be the say. And in fact, by Lordship's another order of your Lordship on judgment upon admission, I am trying to cover the most as possible. 25 and 30.
Same.
The same ambiguity in the plaintiff's case.
Analogous matter.
Yes. Ambiguity in the plaintiff's case. And thereafter, that is why.
All the 12.6, it is
Very
settled
specific.
law. If the court finds it is unequivocal admission, then only the court
Here
has
there
to
is no
examine
unequivocal
all
admission. There is no clear
defense raised by whether there is specific defense.
Oh yes, that one point left. I have to that one new judgment. I have to. That is not on the ground that they have taken. I have not filed any appeal from that order of 4th March. So I don't think there is any response to that is required, because in that case, from all orders, even from orders of adjournment, the party will file an appeal. But still, copy the order. Yeah, 1960, Supreme Court 941. Copy that. Paragraph 30. Just show one paragraph of 30. 13, 1 3. Just one paragraph for this thing.
Yes.
But,
30.
No, one. But I'll not play upon this. Otherwise, they'll again say, we'll come back and distinguish not necessary. I'll not let it be not completed. Nothing else remains. So one more sentence, my lord. They argued on the question of limitation, which I argued in Order 711. Their argument is COVID-19 pandemic, and because of the Supreme Court order, they could not file the suit. They were not required to file the suit within the time. But my one line answer to that is, Lordship would consider the plaint. It is not their case in the plaint. The Supreme Court order is not referred to. There is no inability expressed in the plaint under what circumstances they were restrained from filing the suit. That pleading is completely absent. It's just a submission made from the bar. And the Honorable Supreme Court judgment will not come in the aid in the absence of pleadings. There is not even a reference to COVID-19 in the entire plaint. And plaint is filed during the COVID situation. So maybe if some party can come to court and file a suit,
When the
yes,
suit is filed,
2022.
on which date?
But I think September. I'll check once again. But I think it's June 2022, 195. So that if 1995, June 2022, they could file the suit. They could have easily filed the suit prior to COVID, and there is no reference of COVID-19 in the plaint. There is no reference of any order of Supreme Court. There is no explanation as to what stopped them from filing the suit. Checks were of 2017. They could not have maintained the suit. It's expressly barred by limitation. The only plausible explanation given is COVID-19 and the Supreme Court orders, which have no reference in the plaint. But those are my sub. I have not cited any new judgment. Kindly restrict my blind friend. I do not know. On facts, he can't argue.
I'm not showing facts. I'm going to show something which.
But how can we, after conclusion of hearing,
only 2-3 points, my lord.
What?
No.
Reply,
Lord, what he has not argued, what I have argued, he has not given a reply to. I just only point out those points.
The court will take cognizance of it if I have not argued.
Lord, my specific pleading was that they have received the money. In the mortgage deed, their signatures were there. Even the plaintiff's signature was there. My PAN number was there, my lord.
Already recorded.
Right. Now, my lord, in the affidavit, my lord, they do not deny receiving any sum. There is no denial of the fact.
That he also submitted that.
There is no denial. The defendant number 1 has received the sum from the plaintiff. There is no denial of that fact. There is not a single denial that I have not received any fund from the plaintiff. Rather, my lord, the bank accounts shows that he has received the money, which has not been argued by my learned friend, my lord. One, my lord. Now, my lord, also, my lord, with regard to, my lord, the checks, my lord, I had specifically stated, my lord, that these are our Xerox copies which was there, the second Xerox copy which they're trying to prove, my lord. My lord, kindly, my lord, take and show the admission, my lord. Page 11, paragraphs dealing with, in the affidavit, page 11, paragraph 7, my lord. Of their affidavit. Affidavit দিয়েছে তো আবার affidavit দিয়েছে সবসময় দিয়েছে এই কোন affidavitটা তোর ভাই একটু বল কোনটা দেখাচ্ছ আমি কি করে জানবো তোদের এতগুলো affidavit দিয়ে কি করব বল মানে GA3 মালড হ্যাঁ GA3 হ্যাঁ তো এরকম চেঞ্জ করেছিস না যেটা
মানে এরকম আমারটাকে দেখিয়ে দাও।
দেখিয়ে দাও I think my lord it should be my lord page 8 in the
Page 8 of affidavit.
and affidavit, my lord.
Yes, you're treated
Yes, my lord. I have stated, my lord, only my lord, that point, my lord, they have not controverted this issue at all, my lord, that they have received the fund, my lord. And my lord, only one thing, my lord, no issues are remain pending, my lord. No issues, my lord, in the suit will remain pending, my lord. Because, my lord, with regard to the name, my lord, I have shown, my lord, it is they who have correct. It's by mistake, my lord, which has happened, which is an admission portion, because they have taken the money. So, my lord, the issue, there is no issue will be pending. If my orders 12 rule 6 application, my lord, is allowed, my lord, all issues has been adjudicated upon, my lord, will be, my lord. It is not this case that our issue is pending. If this application is allowed, then our issue has not was not answered.
Yes.
Because, my lord, all the issues which they have raised, my lord, have been argued and are being adjudicated upon. So, therefore, evidence won't be required to be called for. Because all the documents are on record, my lord, and from the documents we are showing. There's nothing oral, my lord, here, my lord. And, my lord, the latest judgment of the Honorable Supreme Court, which is, my lord, has come very recently, my lord.
Judgment in
I don't want to show, that is, my lord, 2025.
কপিটা দাও তো কি তো বলতে হবে তো
Lord, Well, it shows well, the admission. Let me see. It shows well, the admission can be. The court can take cognizance of any admission, my lord, at any point of the stage of the suit, my lord. This 2025 Supreme Court online, my lord. It's 751.
কপি দেবে কোর্টের জন্য
দিয়ে দিচ্ছি, copy দিয়ে দিচ্ছি, my lord.
তখন তাহলে বলে দিচ্ছি আনসার
Only on that portion, my lord.
751.
751. My lord, it shows one of the amended portion of the CPC, my lord, of the Order 12 Rule 6 and the Law Commission report, my lord, and says that, my lord, all the judgments, Uttam Singh Duggal and all have been cited. Now, my lord, kindly, my lord, takes paragraph 37.
otherwise lordship is also going otherwise. Lordship asked me particularly on this
37, 38, my lord. 39 again, my lord, has been cited. The admission is thus logical. Judgment on admission, my lord. 42. 44 also, my lord. So, my lord, here, my lord, no issue. My lord, what my argument is that, my lord, that no issues will have been pending, my lord. All issues are being answered, my lord.
Okay.
you want to see judgment has been cited. I will type like one sentence which is not otherwise somebody has to
It's all
qualify.
settled law.
There is no doubt. There is no admission at any stage. That is my
And, my
submission.
lord, the
That's
mistake.
why that is the discretion of the court.
That's-
If the court satisfied, it is the unequivocal admission, then it can be.
Their party must admit to repay or liability. There is no question of any such admission.
And WC Bins, my lord, 1937 judgment, it was the plaintiff who was taking good of the mistake of the defendant.
That's what I told the judge.
Yeah, my lord, he is taking the good
that
of
is
the
what I
job.
and the quantities were held to be not entitled.
And
So
plaintiff
will
was-
be
you
you
can,
in
that's the reason you cannot be entitled too.
I am not the plaintiff. You are the plaintiff who is
Plaintiff
talking
was-
about mistake.
Plaintiff consultant suffering
You
for
are
the
taking good of the
defendant.
mistake.
Hearing in connection. You file both
File
file
a
written notes of argument.
I can find
Let me be filed, my
Uh,
lord.
Hearing in connection
Okay,
with
fine.
GA3 and GA4.
So then if I could be.
GA3 of 2023 and GA4 of 2024 is concluded. Parties are directed to file their written notes of argument by
Not by today's
today we
Friday,
are on
Lord.
21 by 5th of May.
Grateful, my lord.
By
Only
5th May
claim.
2025. This is the matter on 5th May 2025 under the heading for filing written notes of
Lord,
argument.
do we annex the copy of the judgments which you have cited, my lord? The copy of the judgment, this one, 2025
Give the
judgment. my lord?
copy to him, then he also
I'll
give-
deal it in my
Take my
deal,
notes.
he will deal in,
It's a very recent judgment of Supreme Court, my lord.
correct, you deal with that.
I'll deal.
Order to ask you. Order any, order any. Affidavit to ask you. Very good. Don't know.
এটা কি হয়েছিল জানো? কিন্তু তো আকেও নিতেছি।
Yes.
ফোনটা পরে ওকে ঝাড়ছি। আমি গিয়ে ওকে পাঠিয়েছি। ও আমাকে তোমার কেন শুনুন?
Item 15, please, Your Lordship, my lord. I am appearing for the petitioner in several petitions, my
My
lord.
lord, I appear for the plaintiff. My lord, the matter was
My lord,
initially,
application.
it's a substitution application. It was fixed on
This is the
16th.
matter, my lord, which I
16th.
had. My lord,
May I
this
submit
is the
only
matter
one
which I had mentioned, my lord, because I need to, my lord, be fair to the honorable court. We had given notice on all the parties, and I had mentioned the matter because, my lord, there was some difficulty. We could not represent the matter properly, my lord. And at the time of rising of the court, my lord, upon notice to all the parties, I had mentioned for the matter to be made not today, so that, my lord, it retains a position in the list. My lord, this is that matter. My lord, there are several applications on board. My lord, GA8 is, my lord, my application for substitution, my lord, which I, my lord, seek to proceed with. I'll indicate, my lord, this, if it's a complete in this
But
petition,
prior to,
there's-
my lord,
and I'll indicate, my lord, affidavits are complete, and I'll indicate what the matter is. My lord, this is a matter of course under Order 22. I will indicate, my lord, because today, my lord, it's my petition. I'm sure, my lord, friends.
My suit.
I'll indicate.
My lord, this has been pending for 2024. What is his
I am
hurrying urgency?
defendant number one in the main suit. I'll indicate what the matter is in a nutshell, my lord.
So
Since
what
we are
you want now?
today, my lord, substitution is all that I want because there's a counterclaim which we have filed. We have
You are
filed
for
a
the defendant number
counterclaim.
one.
I'm for defendant number one.
I only apprise
For
what
substitution.
It's our application for substitution
And
of the
number one?
plaintiff's heirs. That's GA8.
But I appear for the heirs of the plaintiff number 1. I'll tell you, Lordship, Milord, on the last
Plaintiff
occasion.
number 1 has
If I
not-
may get
may I-
only
may I
Milord, 1
indicate-
minute of
may I
audience.
indicate the facts
1
first?
minute of audience.
It's
before
my
that.
petition. I'm sure my learned
okay,
friends will permit me
minute.
to
I
argue.
will go by serially. Who is
I don't
I'm
understand
the
this.
petitioner.
My lord,
I'm the petitioner. This is my petition. So may I indicate
My
what the
lord, I am
matter
being-
is very briefly?
let
So only this reason. I'm sorry, my lord. I would not.
kindly control himself a little, my lord. My lord will be reminded, my lord, very respectfully, and I say this with all humility. The matter was appearing in your lordship's list on Friday. We received a notice at 2 p.m. saying they would mention the matter. We all came. Nobody mentioned the matter. The matter was called on at 2:30 or 2:40. After hearing in the presence of all the parties, including Mr. Bag's juniors, my lord was pleased to fix all the matters on the 16th of May by passing a formal order. After that was done, my lord, suddenly we receive a notice at 3:50 after half an hour that the matter would be mentioned. My lord, we immediately WhatsApp them saying most of the people have left, please do not do so. Then a formal notice follows, which is served on us 15 minutes before, and the matter was mentioned before your lordship. My lord, this is a highly contested matter. My lord, it cannot be done piecemeal like this.
correct. So
And secondly, my lord, affidavits on behalf of the defendant numbers 2 and 3, so far as GA number 8 is concerned, I have not yet filed my affidavit. I need, and because, my lord, they were busy, my lord, doing other applications before another learned judge. I will not go into that. And because, my lord, they did not meet with success, they pushed up the appeal before the appeal court. The appeal court, my lord, the appeal was filed in 2020. The death took place in 2023. Today we are in 2025. And suddenly, my lord, this urgency just to get the GA number 8 heard.
And
I am not saying it should not be heard. But since my lord was formally pleased, my lord, to pass an order that all the matters, by listing all the matters.
let me know how many applications are pending. GA8 is your application.
That's my application for substitution, my lord,
Regarding the
and I'll
death-
indicate.
The
my lord.
pleadings are not
Pleadings are
complete.
complete.
No,
Pleadings
pleadings
are
are not
complete
complete. I have
because-
not received a reply.
Yeah,
have
I
not
don't want to
received a
file a reply. I do not want to file a
You have
reply.
not said that before.
I'm saying it now. It's my
Numbers 2 and
it's
3
my
would like to
petition.
file an
Pleadings are complete
affidavit.
then.
So
An
GA
affidavit-
No. There are several applications, my lord.
I have filed my.
Let me understand.
Yes,
So GA8 filed by the defendant number
One, my lord.
1 for substitution
For
of the
substitution
plaintiff
of plaintiff
two.
number 1,
Plaintiff number 1.
my lord.
I would like to file an affidavit in opposition on behalf of the defendant numbers 2 and 3.
My lord, affidavits are complete,
No.
and I'll indicate, my lord.
You
I'll
are
tell
having
you,
a
Lord.
copy.
Lord, affidavit in
Affidavit?
opposition.
Ah.
Kindly give the copy of affidavit in opposition.
But I have,
GA8.
my lord, filed the affidavit in opposition, my lord.
Let me see whether
Yes, my lord, I have filed the
My lord,
affidavit in
there's an
opposition as the
affidavit in opposition for plaintiff number 3 and the respondent. That's, my lord, on board. There's a second affidavit in opposition, my lord, which is purportedly filed by the legal heirs of the plaintiff number 1, which is not at all maintainable. It's an
No, my lord,
automatic.
I have an application for
and
the
I
accounts
said
to be
why.
taken on record. For the accounts, the
today-
auditors
today,
were
my lord,
appointed
It is
and the
pursuant
accounts
an
to be
order of
Reason
the
is
taken on
court
record.
that we have
made-
filed the affidavit. I appear for the
can't
legal
be,
heirs
my
of, my lord, the plaintiff
I
number
can
1.
make
It was
submissions,
done, my lord,
but I
pursuant to
cannot
an
make
order of
submissions
court.
like this.
Whether it's necessary or not, my learned friend will not say that.
Yes, I
No, no,
will,
I
because that's
also
the
have a
law, and that's why, my
GA10.
lord, I've come with the written notes of submissions. Kindly permit me 15 minutes. I'll make my submissions. I'll file the written notes.
No, my lord, today,
I'm ready.
just like this, it's not
If the
possible.
affidavit is not completed, how the matter can be heard,
My lord,
Mr. Bhatt?
my lord,
That-
opportunity was
that's why-
closed. My lord, kindly take up the order.
Opportunity was closed.
My lord, 14 January 2025. My lord, kindly take up that order.
My lord, I am being led by
My lord,
Mr.
kindly see
Mukherjee.
the
Both
second
of us
last
are in
line.
difficulty.
Second last line, page 2 of the
14
order of
January.
14 January. 14 January, my lord.
14 January order है?
14 January 2025.
13 14 तो नहीं है.
GA8. And kindly see the order is passed in GA8. So what my learned friends are saying is perhaps without proper instructions. Kindly see the second last line, my lords. 14th of January 2025.
So my learned friend's first submission that the legal heirs weren't allowed to file the affidavit in opposition to.
No, I did not say they were not allowed. I said that's the operation of
That's
law,
my
and
lord,
I'll argue
pursuant
that.
to- Pursuant to my lord,
I'll
orders
argue
of
that
court.
that's the point
My
of.
lord, I also have a
Orders of court.
GA10, which is very important. The accounts has to be taken on record. It is about a partnership dispute.
My lord, that can be proceeded with if my learned friend
And my
wants
lord,
to.
the legal heirs, my lord, do not want to, my lord.
They
comment,
don't
my lord.
want to join the partnership firm. Even this is not my case. I'll indicate that once I get an opportunity. My lord, kindly see GA8, the second last line.
Correct.
No further time shall be allowed for filing of exchange of affidavits.
Numbers 2 and 3.
So this is, my lord,
You file an affidavit in opposition.
I object.
It
My lord, kindly
restricts
see
from
defendant
May
numbers 2 and
16.
3 were represented
I
on
don't
that day.
understand what
You
is the
object when
pressing
the
hurry.
matter was
Lordship
taken
will
up on
find
Friday.
defendant numbers 2 and 3 were represented on that day.
Yes.
And this order
and in
was
front of
passed.
them, it was
No
fixed on
further
16th
time
May.
shall be allowed for filing of exchange of affidavit. Couldn't have been clearer than this. Sir, I am only praying, grant me 15 minutes today, my lord. I will finish
No,
my
no, no, my
submissions
lord,
on this.
today it's not
I will
possible.
finish my submissions. They can,
But Mr.
they can
Mukherjee is
reply on another day.
not available. He's
My
aware of it.
submissions are to finish. I have my lord, I have my notes. I'm ready to make the submissions, my lord.
Mr. Bhag, you all persons are senior. On the mouth of the advocate, court cannot walk. Court has to go by the law
Indeed,
and
indeed,
go by the procedure.
indeed, indeed.
And court has to give the opportunity to all. One
Since it's
order has been
closed-
passed by the court. It cannot say that yes, you can argue and the court will pass the judgment.
Very great.
No, no, it is only, my lord.
Please.
There is an extreme urgency. That's why, my lord.
It was
Otherwise, I
my
would not have-
mistake. I have recalled that order. It was my mistake. Henceforth, I will not.
But I apologize, my lord. That is my fault. I should have, my lord.
For the last 15
being
minutes,
present.
I'm telling, let me understand what is the matter.
I'm
You
sorry.
are arguing the matter within 15 days. You will conclude. If you conclude the argument, how the opportunity should be given to the other? They have not filed the affidavit, but the court has to.
I understand that, my lord. There's an only because there was an urgency, my lord.
What
Otherwise, I would not
urgency?
have-
You filed the suit in the 2024, 2019.
My lord, the urgency
Subsequently, it is going on.
GA11 and GA9, my lord, which was, my lord, GA9, my lord, was
So many.
ordered
That
against
is the
us.
problem. In every case, about 4 or 5 interlocutory applications in filed by the parties.
My lord, here
The
the
court is
matter,
burdened with the documents.
I understand that, my lord. The difficulty
And
which
one fine day, one advocate will come. Yes, this is the urgency. This has to be heard.
may I indicate in a minute, my lord,
This
what
is
is?
not the way.
I understand. I apologize, my lord.
And you know, this court will not keeping any interlocutory.
I-
All interlocutory
bow down,
application
that
is being
is-
taken together.
Indeed, indeed. That is what was indicated
Because
on the
this
last
court
day
is
also.
facing difficulties in
I know.
earlier so many matters. One matter is heard, no judgments. So matter is pending. So
Indeed.
that's why this court has taken a decision. All interlocutory application is to be heard together,
My lord.
either this way or that way.
In fact, I remember, my lord, when I had mentioned, your lordship was very clear that I'm not going to put one application. It has to be all the applications.
Correct.
I bow down, my lord. That
Correct.
that was
fixed for
indicated by the
16th May.
honorable court.
Otherwise, it will be difficult.
I understand that.
difficult
But
for this
I
court.
apologize, my lord. I should have indicated on that day. I should have been present on the correct time. It's my fault, my lord. Kindly don't take me amiss. The
How many
difficulty,
applications are pending?
my lord, there are, my lord, GA4, 7,
4, 7,
my lord, 8, 11,
8, 11,
8, 10, 11.
8, 10, and 11.
My lord. Out of this, my lord, GA8 and 11 are my applications.
8 and 11 of the defend number 2.
Defendant number 1, my lord.
Defend number 1.
My lord.
And 4 is? Who has filed the 4?
What is filed by whom?
7 and 11 are filed by 7 and 10 are filed by plaintiffs.
What? For what?
7, Lordship, it was the application to extension of time to file the requisite reports.
And my lord, 10 is to file the auditor's report. There was an interlocutory order by
Okay.
which we were to file the auditor's report.
With regard to other applications, affidavits have been completed? Not.
11 is complete, I know,
11 is complete.
as far as I know.
10, no affidavits have been filed yet. Your
10,
Lordship.
no affidavits are filed.
So appearing for the plaintiff number 1. So appearing for the plaintiff number 3. So appearing for the defend number 1, and so appearing for the defend number 2 and 3. It is fine from the record altogether. 5 applications are pending, being GA4, 7, 8, 10, and 11. Year dekh lena. Year. Full. So counsel for the defendant number 1 is pressing for hearing of GA8 of 2023, wherein the defendant number 1 has prayed for regarding the death of the plaintiff number 1
My lord.
and substitution of the legal heirs of the plaintiff number 1.
Right.
Fully so. Some of the parties some of the appearing parties submit that the affidavits have not been completed and they requires to file affidavit in opposition in connection with GA10. Learned counsel for the plaintiff defendant number 1 has brought to the notice of this court to the order dated 14th of January 2025, wherein this court has allowed the time to file affidavit in opposition. Full stop. Affidavit in reply within 1 week thereafter. Full stop. And this court has further ordered that no further time shall be allowed for filing exchange of affidavits. Counsel for the defendant number 1 submit that the none of the submit that in terms of the order passed by this court dated 14 January 2025, no time shall be allowed to file affidavits, and he prays for hearing of expeditious hearing of GA 8 of 2023. Learned counsel for the defendant number
2 and 3.
2 and 3 submits that though there is an order, a specific order, but due to some unavoidable circumstances, affidavit could not be filed, and a prays for extension of time to file affidavit opposition. At the learned counsel for the respective parties, this court find that altogether 5 interlocutory applications are pending. Full stop. In some of the applications, affidavits have been filed, and some of the applications, affidavit have not been filed. In view of the above, full stop. This court is of the view all the application has to be heard together and to dispose of for future complications. In view of the above, the parties who have not filed the affidavit in opposition, in view of the above, the parties are directed to file the affidavit in opposition, if any, required within a period of 2 weeks from date. Reply, if any, they are to be filed within a week thereafter. List the matter on 20 May 2025.
23. But may kindly do not take me amiss, Milord. I apologize. It is
okay.
the only reason I was pressing is, Milord, the medical emergency. Otherwise, I would not have.
But what can be done?
I understand that, Milord. Kindly don't take me amiss. Milord.
Grateful, grateful.
I'm very deeply
Grateful.
obliged. Very deeply obliged.
Kind leave, may I mention 3 matters? I had mentioned the matters in the morning.
Yes, all three will be listed on Wednesday.
Interim order may be extended till.
Your Lordship, I'm appearing for the ROC in this matter, Your Lordship.
What
In the
about the
two matter.
interim order?
Your Lordship, the interim order can be extended, Your Lordship. Your Lordship, I've already filed my affidavit also, Your Lordship.
What is the interim order?
That no coercive steps shall be taken by the ROC.
So and so appearing for the petition. The matter is being mentioned by the learned advocate appearing for the petitioner upon notice to the respondent full stop. Counsel for the so and so appearing for the petitioner, so and so appearing for the respondent number 2. Counsel for the petition submitted the interim order granted earlier is going to be expired today and paid for extension of the interim order. In view of the submission made by the counsel for the petitioner, interim order granted earlier is extended till 30th April 2025. Let the matter appear on 30th April.
Oblige, Your Lordship.
Yes.
Lord, I appear defendant number 2 and 3.
Argument?
My Lord.
Yes.
My Lord, first I recapitulate, my Lord, the fact, my Lord. My Lord, in this suit, my Lord, the defendant number 1 to 3 intended to construct a bridge between Eve and Brajraj Nagar station.
That I have taken note. Now
Very good.
you have,
Yes.
on the last occasion, you are argued with regard to the issue number 2.
Issue number 2.
Yes.
And before that, my Lord, issue number 1, my Lord, I submitted, my Lord, on issue number 1, my Lord. The cause of action in the instant suit has not arisen within the territorial jurisdiction of this court. But the plaintiff states, my Lord, that part of the cause of action arose within jurisdiction of this court. In this respect, my Lord, I cited 3 judgments of this honorable court. Those judgments are, my Lord, reported in, my Lord, the AIR 1970 Kolkata.
Yes, 1970.
Kolkata.
1970,
Sorry to interrupt, Milad, but this part has already been argued by him.
Correct. That's what I'm telling. Yes, I have taken note of it.
You know, the 3
Yes,
judgments
judgment
I
you have
cited,
cited. Yes.
and wherein, my Lord, in paragraph 9 of the judgment of 1970, AIR 1970 Kolkata, my Lord, it is stated at page 395 that
Yes, I taken. You already argued, Mr.
Cause of action. That everything is not the cause of action. My Lord, that it should be effective.
Correct.
That is, my Lord.
I have taken all 3. I have taken note.
My Lord. So, my Lord, this. Therefore, my Lord, my submission is, my Lord, that there was no cause of action within the jurisdiction of this court. Secondly, my Lord, the defendant railway is not having any office within the territorial jurisdiction of this court. Therefore, original side rule will not apply. If there is an office, any office, then it could. But here there is no office at all of the defendants within the original side jurisdiction of this court. Therefore, my Lord, these 2 count, my Lord, no cause of action and no business carried out within the jurisdiction of this. Now, my Lord, issue number 2, whether the plaintiffs fail to perform any part of the contract despite the same being achievable under the contract conditions. My Lord, the defendant's railway submits that the plaintiff failed to perform its obligation to complete the project despite the same could be completed by the plaintiffs for the following reasons. My Lord, I place, my Lord, Exhibit D. Exhibit D, my Lord, is the contract, my lord, DD 31 or DD 11. My lord, here from the contract, that is the exhibit D, my lord.
Yes.
I will place before your lordship chapter 12, special conditions of contract.
Correct. 7.1.
5.1 and 7.1. Okay. 5.1, my lord. First I am placing. Have your lordship got it?
Exhibit D.
Exhibit D, my lord. Exhibit D.
Okay. 5.1.
5.1. That is the, my lord, chapter 12, special condition of contract. That is a part of the contract. Here, my lord, 5.1 is the, my lord, regarding before that 5. 5 is the sinking of wells, and then 5.1 is the provision. The cups shall be placed and cast truly in position. The staining shall be constructed in stages, and the well vertical with permission with limits as detailed in clause 6.1 to reach to final founding levels as required. Suitable method of sinking other than pneumatic sinking may include open dredging with contractors construction plan, employment divers, and use of explosive. Use of explosive required in the process of normal sinking. However, no claim due to any obstruction such as isolated boulders, log of trees, sunken boards, etc. met with during sinking or due to any other difficulty experienced in the process shall be entertained. So here the claim is there is a hard rock, but these all mentioned here, my lord, this can't be entertained in 5.1, my lord. Then, my lord, I will place, my lord.
What is the issue number 2?
Issue number 2 is, my lord,
failed to perform any part of the contract despite of the same being achievable under the contract conditions.
Yes.
Yes. So you are relying upon 5.1.
5 point.
The crop shall be placed on the cast truly in possession. The testing shall be. This is the method.
Yes. So therefore, the any test, my lord, that is a hard rock. It can't be entertained. Even the normal sinking and such as the isolated boulder is found during that my lord, the digging, my lord, log, tree, or sunken boards, or the hard rock, it can't be entertained.
Where it is mentioned hard rock?
Hard rock is not mentioned, my lord. The other things are mentioned, my lord. Here, that hard rock I will come later on. It's also there. I will come to that, my lord. Then, my lord, I will place before lordship the 7.1 of the, my lord, the chapter 12, special condition of contract, chapter 7.1, use of explosive. As you got it, my lord. 7.1, explosives shall generally not used as an aid for well sinking. However, in cases where explosives are to be used, prior approval of the engineer shall be obtained. All prevalent laws concerning handling, storing, and using of explosives shall be strictly followed. If blasting has been used for setting the well after it has reached the designed foundation level, normally 24 hours shall be allowed to lapses before bottom plug is laid. So here is the provision is more for use of explosive. This is my I want to show before lordship. There is a provision for use of explosive if there is any hard rock during the, my lord, carrying the contract work, my lord. Then, my lord, in this regard, my lord, I will, my lord, so, my lord, the In cross-examination, the plaintiff witness number 1 in question number 283 and 284, an answer thereto recorded as under. The
Question number?
Question number 283 and 284. Of the witness number 1.
One.
Question number 283. This is the deposition of the witness 1 of the plaintiff, Mr. Pradeep Khutan.
Yes.
Question number 283.
Yes.
In cross-examination, question was, my lord, did the plaintiffs applied before the defendants for granting permission for blast at the well foundation site as provided in the contract? This is the, my lord, question. And what the answer has been given, my lord? The plaintiff kept the defendant informed of the situation. Elusive answer. Not the clear answer, it's an elusive answer.
Yes.
Then next question, 284. Whether the defendants, after receiving information, request to carry out blast at the well foundation site to remove the hard rock, decline to grant permission for the blast to the plaintiffs. In cross-examination, the answer of this question, my lord, the defendant did not pursue with the blasting as the solution probably due to various technical and safety related issue and could not offer complete solution to the plaintiffs later. Elusive answer, not clear answer. Whether permission granted or not, yes, no, no, elusive answer.
Yes.
Then, my lord, the witness of the defendant railway stated, that is, my lord, in that question number 91 of the defendant witness number 1. Question number 91.
91.
My lord.
Fine. 97, 95, 96.
My lord, exhibit 5.
Just a minute. Yes.
My lord, in question number 91, shown a letter dated 4/5/2012. My lord, that this letter is
From the
4/5,
number
yes,
1 to
exhibit 5. This is exhibit 5, my lord.
This is exhibit 5.
This letter is exhibit 5. And the question, my lord, is made here, my lord. Shown a letter dated 4/5/2012 from the plaintiff number 1 to the defendant number 3. Kindly tell the honorable court what is this document. This is the letter